and he's been in y'all's care and custody.
Here's another one. Every notice that the court sends, like every time there's an arraignment, every time there's a evidentiary hearing, a deputy walks over or drives up and gives me a subpoena. Mm-hmm. They do not when the person misses court. They never physically send out. So I was around here thinking all of my clients are good. Yeah. You know what I'm saying? Like all my clients just going to court like smooth sailing. And then I get this forfeiture. But I didn't get it with the notice at the 180 days even still. Because no, he didn't send it to me. Mm-hmm. He put a detective or somebody in a car and drove the notice to Baton Rouge and delivered it to the Secretary of State.
No way.
So I didn't even find out about the court date until the court date was happening. When Stravros got there, I was already forfeited the day before.
Wow.
And never got served on purpose.
I have a question. Were you located here?
That's here in New Orleans.
No. Was your office located where
it
we're
was
currently?
on Tulane.
But yet they drove to Baton Rouge.
He's still doing that right now.
So the unfortunate part, what happened prior to 2017, they used to have to do the service directly to the bail bondsman, to the surety, and to the defendant.
Okay.
Now what they're allowed to do by law is to serve the Secretary of State and use the Secretary of State to serve the surety like they're serving an insurance company.
Gotcha.
So it ends up resulting in a delay of if they get it to the Secretary of State and they've set the court date 35-40 days out, it usually gets to the surety and the bondsman with a week or two left, sometime or sometimes less depending on deliveries. And it was done under the idea that they'd have that tracking. Yeah. But what it usually ends up resulting is just delays overall. Yeah. And the thing is, this was a policy that was taken up by most of the DAs in the state of Louisiana, because they talk about making an organized decision as to how they handle bond forfeitures and bond set-aside notices at the LDAA conferences, where they set common best practices for all Louisiana DAs, and a lot of them use that process now. So we end up having to fight bail bond forfeitures in multiple jurisdictions in this state where notices might not be done correctly, mailings might not be done correctly, and whatnot. Some DAs are more concerned with getting the person in court. Yeah. Some DAs are more interested in getting the money.
Does he get a raise?
Nah, because but the thing is, there is a different issue, because all that bail forfeiture money gets split between the sheriff's office, the DA's office, and the court. So they have a reason to forfeit the money, because then that's how they.
The individual doesn't. That individual ADA doesn't get an.
No.
He just gets brownie points.
That's how he's justifying his job, or he or she is justifying their jobs.
Bless their heart.
The trick bag is, which I think is deceptive, is that if you're gonna do that to ensure that it's done properly, then don't eliminate the regular foot process. Because you could still give a KPS just like you give if you send a deputy for everything else. If I get something for an evidentiary hearing, then I should definitely get something when a bench warrant is issued in the same practice. To me, it's a little bit of deception to say don't send that one. We'll do that. So that's my but that's just my little soapbox, and I'm off of it because I have a great attorney. And even though I had a hole in 2 or 3 of my wigs from pacing the floor and trying to figure out how I was going to get through it, we crossed that hurdle. And I learned a lot about Louisiana law and practices through Stravros. And so we've had these conversations. Like, it's not just that. Like I said, it is, again, freedom is what? Not free. It is not. No matter what. And that's why we want to have these conversations, because this information that we're talking about casually and that we know is second nature, some people think is private. You know, they don't even know that this is free information. And some people won't. You know, you have great attorneys like yourselves that are able to say, hey, everything's not always right, and this is what we got to do. This is how we play ball on this side of the court. And people need to know. So the people that are watching and the people that are listening need to get an opportunity to know that, hey, they can call Stravros. They can call Dewan. They can ask questions. They can get a consultation. Because when they call me, I tell them, hey, I can't give you real legal advice.
Right.
You know, that's not, I can tell you what I've been through, but some of these bridges I haven't had to cross, thank God.
Yeah.
But we do need to keep an open line of communication as to, hey, what is the benefit of really having a private attorney versus a public defender?
Oh, is that a question?
It is open-ended.
Oh, okay.
Education is super important because people need to know, and the thing is that they need to be able to know for themselves and be able to research, but also know where the limitations on research might be and when you want to talk to an attorney. One of the things that we encounter regularly is sometimes we describe them as jailhouse attorneys.
Oh, God.
And the thing is that it's a double-edged sword because you always want to have every client to have as much knowledge as they can, because with knowledge they're better able to and equipped to handle any situation.
Yeah.
The danger always becomes cherry picking. You never want to cherry pick the law that you think applies to any particular situation, and you never want to cherry pick outcomes, thinking that this one very specific situation that was a little unique will apply to every situation under the circumstances.
That part.
Because you'll have situations where people make assumptions based on what they understand of something that's happened before in a similar case
To someone else.
And
like they're always like, this guy got, but he got this, and it's just like everybody's cases, everybody judges, everybody prosecutor is different.
Say that last one. Everybody's judge.
Judge is different. The prosecutor is
the
different. The victim
have
is
temperatures
different.
like tea kettles.
Yes.
You don't know what kind of, you know.
Yes.
every single element of that is made up of people, and people are people. They will be how they want to be on any given day, and you never know for certain. And it's oftentimes you want to try to be able to tell a client, I understand where your position is on this, but understand that all these other people don't have your particular personal interest in it. And oftentimes there's a lot of concerns about people having to look out for their own interests while they're in their job. Some people talk about, can't they just give me probation, give me and let me go? Wasn't that serious. But then you'll have a judge who just on the news a week before had one of their decisions attacked in the news, and they got a lot of bad press as a result. And they're worried about getting reelected in the next cycle.
So electric chair.
So exactly.
A drunk bike ride, right? Like, I'll never let that happen on my watch.
Right.
People don't get it. I've seen it. I know what you mean.
It's a real thing.
We've had circumstances where judge lets somebody out on bond because there were legitimate reasons why that should happen, and that justice would be served by that happening. And the thing is, 9.5 times out of 10, that it's the right decision. It works out perfect, and justice has been served. That 0.5 point out of 10, something happens that was unexpected, and somebody gets hurt or a tragedy occurs, and that judge will get unfairly attacked, saying you can't ever do something like this because this might happen. There's been such a obsession with being concerned with the outlier possibility, the smallest worst possibility, and using that to make the decision that everything else can't possibly occur otherwise, just to prevent that very small possibility. And a lot of injustice happens as a result. One of the things that occurs with domestic violence charges now, every domestic violence is serious, and it's always serious, but some domestic violence charges are not the same as others. But oftentimes they'll be treated with the same brush, painted with the same brush. There's a law in Louisiana that says minimum 48-hour hold for somebody who gets arrested for a domestic violence charge.
That's the Gwen's law.
That's the Gwen's law.
Yeah.
48 hours up to 5 days. And that's whether or not we're talking about domestic violence involving somebody getting their face caved in, or if I pushed you slightly on your knee. It's the same
or
thing.
like get out my way. Like,
I know.
You know how.
I see it.
I
see it
say
here
if I
all
would
the
ever be a
time.
prosecutor, I would be probably a great balanced domestic violence prosecutor or a judge, because I've represented, Lord knows, like hundreds of men on DV charges, and it's like a lot of times it's the women weaponizing the police against the men. There are a percentage of men who are abusive and who are abusing women, but a lot of times that is not what it purports to be at all.
On the domestic violence cases, and I know we talked about the women being able to weaponize circumstances against the men, and I see it often.
happens with men weaponizing the system
That
too.
was my question. The hard part, the hardest part to deal with. It's easy to me to figure out when the women are weaponizing and when they are. But what about these cases when it's the man?
Yeah.
And the man does something and everybody thinks that automatically the woman,
I have an example, but I didn't represent this person, but
well, we just gonna do law gossip.
Oh, well, yeah. So I know someone who, I know this woman.
No names.
No, I know.
Right.
I know this woman who had been a victim. Well, she was in an abusive relationship. I would say that. And this one particular time, her child's father, the abuser, came to her house, started the fight, came to her house and crossed her front door and started beating on her, and she fought back in retaliation. Police was called and she was arrested. She had to go through the whole system, and it's she had so much proof that this man has been, abusing her, and it's it was not, the law was not on her side.
Hello, why is he here at my premise?
At her house. It wasn't as if they were in a neutral place or she was at his. She was an actual victim of home invasion due to the elements. When you go to somebody else, you're not invited, and you come in and you commit a felony?
Yes.
Home invasion. She was a victim, but yet she was treated as a criminal. And there are times I have somebody I represented who suffered abuse by hands of an attorney, and when she finally acted out, wait, hold on, I'm sorry. Let's just say they got into one of their little fights, and he bust her head open a little bit, and so she had to go get stitches.
Okay.
And while she was there, she didn't have any plans on telling on him, but
He filed first.
the police asked and she had to tell him, and so he got arrested. So while he was at the police station, she's like, well, since you're gonna press charges against me, well, I got proof that she hit me on this day, and he had some cameras in the apartment, and she was threatening to hit him with something. But why did she get to that point? Can we talk about
That's
that?
the ugly part of domestic violence.
Yeah, and so they both had cases or charges against each other. She was charged in city court and he was charged in state court, and I'm not going to give where at, but yeah.
But guess what? That's everywhere in America. That's case that happened yesterday. Somebody's doing it right now. Right now, unfortunately.
Yeah.
It is.